A couple of weeks ago, we talked about the overview of the Malaysian civil litigation process. In there, we spoke about shortcut proceedings such as summary judgment application. To view that video, we'll share a link at the description below. Today, we'll share how summary judgment applications work and how one can make use of it for speedier debt recovery. To encourage us to make more videos like this, please like, share and subscribe. We will really appreciate it. Thank you. Upon initiating a suit in court, the plaintiff can apply for a summary judgment. Where there is a counterclaim, the defendant can also initiate a summary judgment for his claim. A summary judgment is simply an application for immediate judgment without having the need to proceed with trial, i.e., hearing testimonies from witnesses in open court. The objective is to dispose the matter in an expedited manner with cost and time saving in mind. Summary judgment in Malaysia is governed under Order 14 of the Rules of Court 2012. A summary judgment application can be applied once the summons and statement of claim is served on the defendant and the defendant has entered appearance in the action. The defendant, on the other hand, can apply for a summary judgment on his counterclaim once he has filed and served his defense and counterclaim. For the purpose of this video, we shall refer to the party applying for a summary judgment as the applicant and the party responding to it as the respondent. A summary judgment application is applicable to all claims except a claim for defamation, malicious prosecution, false imprisonment, seduction, or breach of promise of marriage, and a claim based on allegations of fraud. When filing a summary judgment application, the applicant must affirm an affidavit to explain the basis of the claim. Evidence of how the debt or claim occurred must also be enclosed and shown in the affidavit. The affidavit must be in accordance to Form 13 prescribed in the Rules of Court 2012, where the deponent must state that at the commencement of the action, the respondent is justly and truly indebted to the applicant the said amount and that the debt is currently still owing. He must also state that he believes that the respondent has no defense to the claim. Basically, the applicant must produce evidence to show that the claim or debt cannot be disputed and there is no reason why the respondent shouldn't pay. The respondent will then rebut the claim by affirming an affidavit in reply to show why the case is not as straightforward as how the applicant depicts. All the respondent needs to do is to show that there is a possible and justifiable defense, which is best to have the matter cleared by hearing the witnesses at the stand. If the applicant had complied with Form 13 and the judge is of the view that it is a straightforward matter and the respondent has no defense, a summary judgment will be granted. However, if there is doubt in the evidence, or the court finds that there are issues to be trialed, or if the court is satisfied that there are other circumstances that ought to be investigated, the summary judgment will not be granted. In court, it's all about the evidence. If there's a debt owing, or if there's a claim resulting from a breach of contract, a summary judgment can be a useful tool. One will just simply need to ensure that the documents are in order and the evidence are properly recorded. For example, if a debt is owing due to goods sold and delivered, it would be good if documents such as purchase orders, delivery orders, and invoices exist, and it would be best to have them acknowledge receipt by the recipient. If partial payments were made or if there is no dispute with regards to the delivery and quality of the goods, it would be best to have them documented in a letter or an email. Another example is where there is a claim resulting from a friendly loan agreement. Documents such as a contract, proof of payment, and evidence of the breach would be essential for a summary judgment application. Although there is no hard and fast rule of what documents are required, having more evidence is indeed better. If you can elicit an admission or confirmation of the debt or claim from the respondent, that would help even more. I'll admit that litigation is not cheap. That is why summary judgment application can help to reduce those litigation costs. Shouldn't you then take advantage of this by making sure that your documents are in order? We did, after all, just give you some tips on how to win your case and save you some money.